If you are a green card holder living in the United States right now, what I am about to share with you in the next few minutes could be the most important thing you watch all year. I am not exaggerating. In 2026, there are 5 critical immigration changes that are already in motion, and if you are not aware of them, you could face unexpected tax bills, get stopped at the border, lose your permanent resident status, or even find yourself in a situation you never saw coming. These are not rumors. These are not maybes. These are real confirmed changes that are affecting green card holders across the country right now, and most people have absolutely no idea they are happening. So stay with me until the very end of this video, because every single one of these 5 points matters, and missing even one of them could cost you everything you have worked so hard to build in this country. Welcome back to USCIS Explained, the channel where we break down everything you need to know about living, working, and staying legally in the United States. If you are new here, make sure you hit that subscribe button right now because we publish content like this every single week, and you cannot afford to miss it, especially in a year like 2026 where immigration rules are shifting faster than ever before. Now, before we get into the 5 changes, I want you to understand something very important. Being a green card holder does not mean you are untouchable. It does not mean you are immune to immigration enforcement, tax obligations, or travel restrictions. Your permanent resident status comes with serious responsibilities, and in 2026, the United States government is making it very clear that they intend to enforce those responsibilities more aggressively than they have in years. So let us get into it. The first change, and honestly, the one that is catching the most people completely off guard, is the new global income tax reporting requirements that the IRS is now enforcing with far greater intensity for permanent residents. Here is something that shocks a lot of green card holders when they first hear it. The moment you became a permanent resident of the United States, you became a United States tax resident. That means you owe taxes to the United States government on every single dollar you earn anywhere in the world. Not just the money you make in America, every dollar. If you have a rental property back in your home country, that income is taxable in the United States. If your family sent you money from overseas, the IRS wants to know about it. If you have a bank account in another country with more than $10,000 in it at any point during the year, you are required by law to report it using what is called an FBAR, which stands for Foreign Bank Account Report. In 2026, the IRS has dramatically increased its cross-border data sharing agreements with foreign governments. More than 70 countries are now automatically sending financial data to the United States, which means the IRS already knows about accounts and assets that green card holders have been failing to report for years. The penalties for non-compliance are devastating. A single willful failure to file an FBAR can result in a penalty of up to $100,000 or 50% of the account balance, whichever is higher, and in some cases, it can lead to criminal charges. We are talking about people who came to this country, worked hard, built a life, and now face massive financial penalties simply because nobody told them that having a bank account in another country was something they needed to report to the American government. If you have any foreign financial accounts, any foreign income, any foreign assets, please do not wait. Speak to a tax professional who specializes in international tax law for green card holders. This is not something you can handle with a basic tax software program. This is specialized, and the cost of getting it wrong in 2026 is higher than it has ever been. The second change involves something that green card holders often take for granted, and that is international travel. Specifically, we are talking about the re-entry rules and how staying outside the United States for extended periods of time can now trigger automatic scrutiny from Customs and Border Protection, and in some cases, result in you being denied entry back into your own country of residence. Here is the rule that most people know but do not fully understand. If you leave the United States for more than 6 months, you are considered to have potentially abandoned your permanent resident status. But what most people do not realize is that in 2026, CBP officers are being much more aggressive in enforcing this, even for trips that are just over 6 months. They are asking more questions, they are requesting more documentation, and they are referring more green card holders to secondary inspection and formal removal proceedings than at any point in recent memory. But here is what makes this even more complicated. Even trips that are under 6 months can now create problems for you if you travel frequently. If CBP officers look at your passport and see that you have been spending more time outside the United States than inside it over the past year or 2 years, they can and do question whether you have truly maintained your domicile in the United States. They want to see that your life is centered here, that you pay taxes here, that your family is here, that you own or rent property here, that you have bank accounts and employment here. In 2026, the documentation you should be carrying when you return to the United States from any international trip is more important than ever. You should have proof of your ties to the United States. Think pay stubs, lease agreements, utility bills, bank statements, and tax returns. If you are traveling for extended periods for work or family reasons, you should also look into getting a re-entry permit before you leave, which allows you to stay outside the country for up to 2 years without automatically triggering the abandonment presumption. But even with a re-entry permit, you are not completely protected from scrutiny, so documentation is everything. The third change is one that hits especially hard for green card holders who have been in the United States for 5 or more years and are either thinking about applying for citizenship or have been putting it off. In 2026, the naturalization process has become significantly more complex and, in some cases, longer. The civics test, the English language requirement, and the background check process have all been updated, and processing times in many field offices have stretched to 18 months or longer in some cases. But the more urgent part of this change is not about the process itself. It is about what happens if you are eligible for citizenship and you keep delaying. Every year that you remain a green card holder instead of becoming a citizen is another year that you are exposed to all of the vulnerabilities we are talking about in this video. A United States citizen cannot be deported. A United States citizen does not have to worry about abandoning their residency when they travel. A United States citizen does not face the same level of scrutiny at the border. Citizenship is the ultimate protection, and in the current immigration climate of 2026, the difference between being a green card holder and being a citizen has never felt more significant. If you have been in the United States for 5 years as a permanent resident, or 3 years if you are married to a United States citizen, please look into your naturalization eligibility now. Do not wait. The window is open for you, and the environment is only getting more complicated the longer you wait. The fourth change is one that affects a very specific group of green card holders, but the consequences are so severe that everyone needs to be aware of it. This is the issue of criminal history and the expanding definition of what the Department of Homeland Security considers a deportable offense for permanent residents. In 2026, DHS has significantly expanded its enforcement priorities to include green card holders with older criminal convictions that were previously considered minor or resolved. We are talking about people who had a misdemeanor conviction 10 or 15 years ago, completed their sentence, moved on with their lives, built careers and families, and now suddenly find themselves facing immigration consequences they never expected, because the way those offenses are classified under immigration law has been revisited. The critical thing to understand here is that criminal law and immigration law are two completely separate systems. In criminal court, a judge might tell you that your sentence is complete and your record is clean. But immigration law has its own definitions of what constitutes a crime involving moral turpitude, an aggravated felony, or a controlled substance offense, and those definitions are much broader and much harsher than what most people expect. Even a simple drug possession charge from years ago can make a green card holder deportable under current enforcement priorities. If you have any criminal history at all, no matter how minor it seemed at the time, no matter how long ago it was, no matter what a criminal defense attorney told you, please consult with an immigration attorney in 2026 before you travel internationally, before you apply for naturalization, and before you do anything else that puts you in direct contact with immigration authorities. An immigration attorney can assess whether your record creates any risk and advise you on how to protect yourself. The fifth and final change we are going to talk about today is perhaps the most sweeping of all, and it involves the broader policy shift around public charge rules and benefit usage by permanent residents. In 2026, the public charge ground of inadmissibility has been reinterpreted and strengthened, and while it primarily affects people applying for green cards, there are important implications for current green card holders who plan to travel and re-enter the country or who plan to adjust their status in any way. The public charge rule, in its simplest terms, means that the government can consider whether an immigrant is likely to become primarily dependent on government assistance when making immigration decisions. In 2026, the list of benefits that can be considered under the public charge analysis has been expanded, and the threshold for what the government considers an acceptable level of benefit usage has been tightened. For green card holders, the most direct impact comes when you leave and re-enter the country. A CBP officer technically has the authority to question whether you are still admissible as a returning permanent resident, and in certain circumstances, public charge can be raised as a concern. This is rare, but it is not impossible, and in 2026, the political climate around immigration enforcement means that these edge cases are becoming less rare every month. The practical advice here is to be mindful of what government programs you are enrolled in, to maintain strong documentation of your employment and financial self-sufficiency, and to consult with an immigration attorney if you have any concerns about how your use of public benefits might affect your immigration status. Now let me bring all of this together for you, because we have covered a lot of ground, and I want to make sure you leave this video with absolute clarity on what you need to do. Number 1, get your taxes in order. If you have foreign accounts, foreign income, or foreign assets, speak to an international tax professional immediately. The IRS is watching more closely than ever in 2026. Number 2, know your travel rights and your travel risks. Carry documentation of your ties to the United States every time you return from an international trip. If you plan to travel for more than 6 months, get a re-entry permit before you leave. Number 3, if you are eligible for naturalization, start the process now. Citizenship is the most powerful protection you can have in the current immigration environment, and processing times are only getting longer. Number 4, if you have any criminal history, consult with an immigration attorney before you do anything that puts you in contact with immigration authorities. Do not assume that because something was resolved in criminal court, it is resolved for immigration purposes. Number 5, understand the public charge implications of any government benefits you receive, especially if you plan to travel internationally or make any changes to your immigration status. Green card holders, I want to leave you with this. You have worked incredibly hard to be where you are. You have gone through a process that most people in the world could only dream of completing. You have built a life here, and you deserve to protect it. But protecting it in 2026 means being informed, being proactive, and not assuming that nothing can go wrong just because you have that green card in your wallet. This channel, USCIS explained, exists because we believe that every immigrant deserves access to clear, accurate, and actionable information about the American immigration system. If this video helped you today, please give it a thumbs up right now because it tells YouTube to show this video to other green card holders who need this information just as much as you did. Share this video with anyone in your life who has a green card. Share it with your friends, your family members, your coworkers, your community. This information is too important to keep to yourself. And if you are not yet subscribed to USA Visa Explained, do it right now. Hit that subscribe button and turn on notifications so you never miss a video. We cover everything from green card renewals to naturalization, from travel tips to tax obligations, and we do it all in plain language that actually makes sense. We are here for you every step of the way. If you have specific questions about your situation, drop them in the comments below. We read every single comment and we do our best to help. And if you want more in-depth coverage of any of the 5 changes we talked about today, let us know in the comments and we will make dedicated videos on each one. Thank you so much for watching. Stay informed, stay protected, and we will see you in the next video right here on USA Visa Explained.